Okay, so that's our answer right here. So.
All right. Like that. Ms. Rivers, are you ready?
Yes.
Ms. Wood, is there anything we need to talk about before Mr. Mosley comes out?
I just had to briefly something on the record when we were locked out in the hallway.
Okay, let's wait till Mr. Mosley's here. All right, Mr. Abadi, you ready?
Yes.
Great. And hi there. I heard you may not be in here, like this, more lies. They're like, oh, I'm staying and.
Yeah, I did got police morning stuff.
Well, it was tough. There's a debate about favorite jasmines. And it's like, oh, this jasmine, and the hope was both, but apparently 8D can only handle one jasmine.
Yeah, we're excited to have her back.
It's a great development. Does that mean fewer courtrooms for you or just different courtrooms? Well, you offloaded a burden, so there you go. Okay, well, at least you're still in the building. Are we good bringing Mr. Mosley out now? Okay.
I got about 20 minutes.
Oh, because it's a Friday for Lethbridge, right? Yeah, hopefully no Cruise Gray.
Where are you from, Mr. Knight? Where are you from? Oh, good.
So when I showed up to work this morning, there was an FBI agent sitting in my chambers. I thought, oh, it's been nice knowing you guys. They finally found me. But a friend and former colleague has been named a new magistrate judge up in federal court. And it was a background check. So I just had to confirm he's not a communist. He's not. So there you go. As best I know. We're back on the record in State versus Mosley. It's Friday, the 27th, a little after 9. Mr. Mosley is in court wearing a bright yellow shirt. Good morning, Mr. Mosley. He's here with part of his legal team, but more than enough for us to go forward. And we have our prosecutors here. Our jurors are trickling in. They're due by 9:30. And we need to talk about the jury charge. But before we do that, Ms. Wood, there was something you wanted to get on the record about being locked out?
No, Judge, while I was locked out, my attorney was with me and Detective Sato was in the hallway as well. There was a juror who got here very early this morning, around 8:45, I would say. And she said, hello, good morning, and I responded, good morning back. And I just wanted to let everyone know what happened.
One, thank you for being cordial. And two, thank you for reporting that. That sounds like it was incidental contact. Can you be more specific about which juror?
I don't remember what number she is. She is the lady who, when we were doing her panel, she said her daughter had a resume or had just graduated college, and she made a joke about wanting to give us her resume.
Okay. All right. Got it. Mr. Abadi, anything from the state before we talk jury charge? All right. Let me get that up on the screen. So on the screen is the document I sent you all last night, which is what I labeled final jury charge. I don't actually have anything to scroll down to. I'm at peace with it, but that doesn't mean either side is. It changed from the last version you had in a couple ways. One, I removed the language about a defendant not testifying, and I tightened up the language about justification based on the evidence as I understood it. So for example, I didn't put in there that self-defense is not justified if it's mutual combat. I mean, the scenarios that I don't think we have, but that was my interpretation of how things progressed during the trial. So I'll start with the state. Want to make sure if there's any edits to the final charge you all think should be made, we talk about those.
I don't say her.
Okay. Ms. Wood, anything from the defense?
No, Your Honor.
Okay. I will get a hard copy of this, one copy to each side. And then there'll be the one I read from, which then goes out with the jury. And then they'll also be able to see it on a PowerPoint that has the language in it while I'm reading it to them. That's all I've got. So I guess we can just wait for the jurors unless there's anything else from the defense or the state. Take that off. All right, and then I'll go make those hard copies and get to work on the PowerPoint, and you all can be at ease. You should have, if you're using a PowerPoint, Mr. Body, just have that teed up, ready to go for when we bring the jurors out. And Deputy Gordon can let us know when we have all 14. And hopefully no one misses whatever bus they need to catch. I'm gonna talk with the jurors, actually Deputy Gordon will, about ordering lunch in so that they can stay focused on deliberating rather than take a break then. That doesn't mean you guys won't get lunch, but they may not be doing we need an hour and we're leaving the building. We'll figure it out. There's a new process, unfortunately, involving something called Easy Cater.
Cell phones in the courtroom.
Yeah. Dang. We're trying to focus on Easy Cater. We'll see if that works. Okay. I'll put things on mute here. You guys can be at ease and I'll come back in when we've got the jury.
Is your first scissors?
No, I just saw you.
Oh,
I just saw you.
They're the ones that he couldn't use. Do you need,
I just need a pair of scissors.
you may want to talk with the deputies before you're bringing scissors back to your table.
Don't break.
Oh, no, I do.
Don't break. It'll do it again. Oh, no.
Here you go. Yeah, do it over here. Mr. Abadi, I don't recognize this morning's beverage. It's not a Red Bull. Yep, please. You have enough ghost in your system?
Okay.
All right. Can you give one to each side? Thank you. Cool. All right, Ms. Rivers, are you ready? Let's get back on the record. It's now after 9:30. All our jurors are here, and they may be restocking. Their snack basket was empty and they were kind of rebelling, but they may just need to be filling their food pouches, and then they should be ready to come out. You're ready to go, Mr. Abadi?
Yeah.
Okay. Ms. Wood, anything we need to get on the record?
No, Judge, thank you.
All right. Give me 1 second. Okay. We're ready for him.
All right, jurors. All jurors are present and accounted for.
Thank you, Deputy Gordon. Everyone else can be seated. Good morning, jurors. Welcome back. Happy birthday, Juror 41. Nice of you to be here on your birthday, now that you had a choice, but I trust your colleagues are taking good care of you. And we were not taking good care of you. I apologize. They brought the little Goldilocks basket back and it had like tooth marks on it. It was empty and someone had been gnawing on it. So we did our best to replenish it. And then Deputy Gordon came running in. They need water. Then he came running in. They need coffee. So you're a needy bunch. But we're doing our best to keep you supplied with non-expired foods and beverages. Lunch will probably be brought in today. There's a new lunch ordering system that was put in place by the county. So it may not work, but the team is exploring that. And we'll talk more about that after we get through what we need to this morning. But that's one way that we try to facilitate deliberations, is say, hey, you can keep doing what you're doing. We'll bring the food in, et cetera. More on that later. Where we left off yesterday, we heard the state's closing part one, and then the entirety of the defense closing, and we broke for the day. So what remains is what we call the rebuttal of the state's summation. It sounds like Mr. Abate will be doing that. So he will speak to you all for a bit, and then I will, at long last, give you the law that you must apply to the facts as you find them to be. With that, Mr. Body, when you're ready.
One of the last things that we
heard yesterday, right before the defense counsel sat down, was how not easy it was for the defendant to sit before each and every one of you and tell you his truth, is what she called it, tell you his story. It was not easy for him to talk about the trials and tribulations he's had in his life. It was not easy for him to tell you about August 11th of 2024. Let me tell you, ladies and gentlemen, from the evidence, from the video surveillance, from all of the things that you've seen, what was easy for the defendant? It was easy for the defendant to stand up and pull that trigger. He pulled that trigger with ease. He pulled that trigger with confidence. He pulled that trigger without any issue. And he pulled that trigger as he pointed the gun at an unarmed man. At an unarmed man who sat on the bench. Now, the defense counsel wants you to believe that Mr. Mathis was armed because he had a knife. But ladies and gentlemen, you heard from the defendant yesterday. He didn't even know he had a knife. The knife was tucked in his bag. No one knew about the knife until Detective Snyder got back to the station and did an inventory of the bag. But what the defendant told you yesterday was that he didn't know anything about a knife. So this whole knife red herring is nothing but that. It's a red herring because nobody knew about it. It wasn't a deadly weapon that Mr. Mathis used to threaten the defendant. You can't threaten somebody with something they don't know about. The only way you can describe the actions of this defendant on August 11th of 2024 is his decision to kill. Mr. Mathis was conscious, deliberate, and was intentional. And he did it with ease. He did it with ease. He did it with ease, as you guys have heard 1,000 times during this trial, on August 11th of 2024 at the Midtown Arts Center station down at 1255 West Peachtree Street here in Atlanta, Georgia, Fulton County. You may wonder why we asked all the witnesses. You know, it is 1255 West Peachtree Street in Atlanta, Fulton County. One of the elements of everything that we have to prove is that each and every one of the crimes occurred in Fulton County. That the venue for each one of the count of the indictment is Fulton County. And what the state has been able to prove beyond a reasonable doubt over the course of the last 3 or 4 days is that this defendant murdered Mr. Mathis. He murdered him. He pointed the gun at him and shot him after they had sat and talked for 31 minutes. Now, something that Mr. Rao touched upon yesterday, but didn't talk about at length, was motive. And what the judge is going to tell you is that proof of particular motive is not required, and that it is legally required. It's all that is legally required to prove murder is that there was an unlawful killing. Motive is like a bonus, and you may ask why. And before defense counsel sat down yesterday, she kept saying Detective Steidel didn't go look for the why. The why, the why. That's because the only person who can tell you the why, the only person that's still breathing that can tell you why, is the person sitting right there. The person sitting right there who had the opportunity to tell Detective Steidel why, but he didn't. What he told Detective Steidel was that his relationship or friendship with Mr. Mathis was cordial. Didn't tell him anything about needing to defend himself, about the weapon, about feeling threatened, uneasy, a bounty. He told him none of that. Absolutely none of that. And why didn't he tell him any of that? Because it's not true. None of it happened. That's why. You want to know who else wanted to know why? Was DeMarco Mathis. You heard from Michael Thompson, who sat before each and every one of you and testified about what he remembered, testified that he did a written statement, which was admitted into evidence. And he said that he watched the two men sitting on the bench. Everything seemed normal, cordial, nothing out of the ordinary. And then the defendant rose, pointed the gun stood over him and shot him. And he said, as Mr. Mathis rolled to the floor in pain and agony, his last words, his dying breaths were, why? 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 He wanted to know why too. He didn't know why the person who he had been sitting next to, the person he had been waiting on the bus for, the person he was going to the same place of work with, stood up and in a second ended his life. And he wanted to know why. But he didn't get that answer. Now, I'm gonna go through quickly, because you guys have heard at length what the evidence is, and how it applies to the laws that the judge is going to give you at the end of the trial when you go back into the deliberation room. And I broke it down into 4 categories. There's the evidence and the lack thereof. There's the witness testimony, which includes the investigation, corroboration, and then the defendant. The defendant's actions, the words, his inactions, and the things he didn't say. And ladies and gentlemen, I want to be clear, the defendant has absolutely no burden. The burden rests solely with the state to prove each and every element of the indictment beyond a reasonable doubt. But when the defendant took that stand, there are certain things he didn't say. And I want you to think about that. There's certain things that he chose not to tell you. There's certain things that were clearly not true. That goes to credibility and the things that Mr. Rao talked to you about yesterday as you weigh the facts and the evidence, the testimony from everything that has come in during the course of this trial. Now let's talk about the evidence. There's the video surveillance, and you've got the surveillance that is the most important, and that's the shooting, the silent witness, because there's no audio to the shooting. We don't know what's being said. We have absolutely no idea what's being said. But you know who could have told you and could have played the video as he testified and pointed to you at the times that he said that Mr. Mathis reached into his bag, that Mr. Mathis pulled out a gun. But first he didn't see what item it was, but then it evolved into the gun that he pulled out of his bag. Then he covered it with his phone, put it to his hip, pointed and threatened. He didn't show you where that happened anywhere on the video. He didn't pull up the video during his direct examination and show you where everything he was acting out and telling you happened. That's because it didn't. That's because it absolutely did not happen. And if he would have showed you on the video, he would have showed you that everything that he was talking about, that everything he looked each and every one of you in the eyes and told you yesterday was a lie. That's why that wasn't done. He executed Mr. Mathis. He stood up, turned, and shot him in a second, ending his life. There's absolutely no justification. Absolutely no justification. You see right before the defendant stands up, he's kind of rocking back and forth. And yes, there's absolutely no audio, but it's as if he's laughing. He's rocking back and forth laughing. You see literally the victim doing nothing. And then he stands up and shoots him. It's an execution. Now I would go through each one of the video surveillance clips, but there's really no point because those clips were used to determine the identification of Mr. Mosley. And that's not an issue because he sat here and told you that he was the one who pulled the trigger when that gun was pointed at Mr. Mathis. The physical evidence that's collected from the scene and the evidence that the defendant told you should be there, but is not. You've got the 2 cartridge cases from the defendant pointing and shooting Mr. Mathis. You've got Mr. Mathis's book bag that you have photographs of in the exhibits that is on the bench that he was seated on before he was shot and rolled off in agony, wondering why. And the lack of the evidence that the defendant told you should be there. The things on the ground were Mr. Mathis's shoes after he fell to the ground and rolled in agony. That was the evidence you found on the ground. What was not found was his phone, was a gun. Because the defendant sat there and told you that when Mr. Mathis pulled out his gun, that at first he didn't see, but then he saw towards the end of his cross-examination, he did see a gun, that it was Mr. Mathis pulled the gun out of his book bag, secured it with his phone, and seconds after he pointed that gun at the defendant and threatened him as he pointed it, covering it with his phone, that's when he told you he stood up and shot Mr. Mathis. But ladies and gentlemen, if that was true, there would be a phone and a gun laying on the floor. And we know that the first person, because you could see it on the video, that gets to the victim who's bleeding and in agony is Mr. Thompson. He told you he didn't see a weapon, saw no gun, and he wasn't asked any questions. What he told you was uncontroverted, unchallenged. It was the truth. Then you heard from Miss Little. And she was there seconds after the shooting, right after Mr. Thompson. She too told you she saw no weapon. Absolutely no weapon. Then you heard from Officer Marcone, who showed up minutes later, told you the exact same thing. All three of their testimony in regards to a weapon is uncontroverted, unchallenged. Absolutely unchallenged. Next, you heard about the evidence that was located in the defendant's home. Now, we'll spend a lot of time on that because that evidence was important, again, for identification. That through the investigation of Detective Steele, he was able to find the exact same clothes that he tracked from the MARTA Arts Center station all the way to East Point Station and to the bus and the bus route that this defendant used on a regular basis. He found the gun as well as the MARTA Breeze card from the days of footage that he watched on August 5th, where the defendant tapped in that plaid button down, as well as his tip-top ID. But all of that became less important in the sense that the defendant admitted all of those items were his. He took away the argument of identity because he said it was him. Now, if this will work, we'll watch the last moments of Mr. Mathis's life. And ladies and gentlemen, what you see there in the last moments of Mr. Mathis's life is not somebody who's threatening someone else with a gun pulled to their side, covered by their phone. You see someone who's caught off guard, unsuspecting, and surprised that the person he'd been sitting next to just pulled a firearm on him. And here you see the defendant walking away from where he had just shot the victim, and there's Field Protective Specialist Little, second behind the defendant, right there. She told you she literally heard the gunshots and went straight to the area. She wasn't playing cop. She was doing her job. She was observing and going to help patrons like she told you she was doing. She never acted, or she never told you she wanted to be a cop. She never told you she was trying to be someone she wasn't. She was just doing her job. The next series of photos are just still shots of what you just saw. And what you just saw is an unarmed, unsuspecting, defenseless man get murdered. These are the other items of physical evidence that found. You've got the two cartridge casings or shell casings that were ejected from the gun that the defendant was illegally carrying. You've got the book bag that is, as you can clearly see, zipped at on all pockets. Before Detective Stidle collects it on August 11th of 2024. Then you have the physical items I just spoke about that were collected from the defendant's home that ultimately prove that Detective Stidle's investigation as it relates to the identity of the shooter, Xavier Mosley, was absolutely correct. That his thorough investigation, that his hours and hours of review of video surveillance from August 11th all the way into August 5th was correct. Then you had your witness testimony, and you heard from Michael Thompson, and we talked a lot about Michael Thompson, so I won't belabor or rehash things that we just talked about. But the key points to remember is that he, again, was the first person who you can see on the video immediately come in contact with Mr. Mathis and saw no weapon of any kind. And what's important about what Mr. Thompson told you is that he immediately took notice of the individual sitting at the bench and saw nothing out of the ordinary, nothing uncommon, nothing, as he said, that wasn't normal until this defendant stood up and stood over the victim and shot him. You heard through Mr. Thompson, DeMarco Mathis's last words, wanting to know why this person he had just been sitting next to shot and killed him. You heard from Terry Bruce, and the main takeaways from Terry Bruce is the lack of evidence, that there was no documentation in the workplace in regards to any issues or conflict between the victim and the defendant, between the defendant and anyone at work. Mr. Bruce, the COO of the company, told you he had access to those documents, and there was no documentation at all in regards to any conflicts that, between the defendant and the victim, and between the defendant and anyone who worked in the company. You heard from Eric Menefee, the former significant other of the defendant, and she told you that she broke up with the defendant the Sunday before he was arrested. That would be Sunday, August 11th, the day in which he shot and killed his coworker, who he had been alleging and accusing Ms. Menefee of having outside affairs, infidelity with his coworkers. And the irony is not lost on the fact that this happens on the day in which she ends the relationship, and it happens to someone the defendant worked with, a coworker. Everything that Ms. Menefee said came true, was true. It's what the facts and the evidence showed. And that's motive, ladies and gentlemen. Now, can I tell you with absolute certainty that was the motive, that was the reason why this defendant killed Mr. Mathis? No. But it's clear Mr. Mathis didn't know why either. Because his last words were why? And the only person who knows is this defendant. And after listening to his testimony, it's something about a bounty, is what I've gathered. But the person he had been dating for over 2 years, who he lived with, lived together, shared his life with, never mentioned anything about a bounty. She wasn't asked about a bounty. And the defendant has absolutely no burden. But if there was a bounty and she knew about it, you better believe there would have been a question asked by defense counsel. And there wasn't, because this bounty didn't exist. This conflict stemmed from the defendant accusing Ms. Menefee of being unfaithful. And he was mad about it on the day that she terminated the relationship, and he killed a coworker who he had been alleging she'd been having affairs with different coworkers. It's that simple. Then there was the MARTA response in the investigation. You've heard about Ms. Little. You've heard about the response from Officer Marthone. And you've heard about the different aspects of the investigation that investigator Steele did throughout the day of and the days following the homicide. And defense counsel yesterday said that Detective Steiner should be ashamed that his investigation was incomplete, had a lot to say in regards to the investigation of Detective Steiner. But the fact of the matter is, ladies and gentlemen, if it was a one-track, use the video surveillance, I got the identification like she said, then he would have stopped at the original video surveillance that he was able to get on the day of the homicide in regards to the shooting and the backtrack. But he didn't. He contacted members of the Chandler Police Department, Abby Bell, had the facial recognition software used, which came back with the identity of Xavier Mosley. He could have stopped there, but he didn't, because he had the identification, according to the facial recognition software, that the person who shot Mr. Mathis was Xavier Mosley. But he kept going. He did research into the background of Xavier Mosley, and he found that he was being supervised by Officer Williams. And he went a step further, contacted Officer Williams, who told you he had been in contact with the defendant for over a year and had met with him at least 2 to 3 times a month during that year, and asked him if he recognized the person in the photo. And Officer Williams and Detective Steiner told you, he immediately said it was Xavier Mosley. So he did all the additional steps that required that many people would have stopped at. According to the defense counsel, that he immediately saw the video and made up his mind. But we know that's not true, because he kept going. He kept taking steps as it relates to his investigation to make sure that he got it right, which is what he told you. Then you heard from the experts in this case. You heard from Dr. Karen Sullivan, who told you the cause of death was gunshot wounds to the torso, the elbow, manner of death was homicide. She told you exactly what Michael Thompson told you, that the defendant stood over the victim, whether he was seated on the ground, and shot him. She told you the trajectory was left to right and downward. Downward. Indicates someone is standing over you. That's how you have a downward trajectory. Then you heard from the GBI firearms examiner, excuse my misspelling, I apologize, Kelsey Nash. And she told you that the cartridge casings and the bullets from the autopsy were a match to the firearm that was found hidden in the blue bin in the attic where the defendant had been hiding, according to him, for 48 straight hours. Now, how do we know all of the facts and all of the testimony, all of the evidence prove that the defendant is guilty beyond reasonable doubt? Because the evidence and the testimony and the evidence corroborates each other. They tell you the same ultimate conclusion, that this defendant is guilty beyond a reasonable doubt. With the no weapon found at the crime scene, which is all the testimony that was told to you by people who first encountered the victim. The videos show the defendant stand and tower over the victim and shoot him. And again, that's corroborated by Dr. Sullivan. Their testimony that there were no known issues between the defendant and Mr. Mathis. You heard that from Ms. Menifee. You heard that from Mr. Bruce. You heard that from the defendant's own eye. And you have video evidence that corroborates that. What do I mean by that? I mean, at age 27, Mr. Mathis and Mr. Mosley sit down on that bench and for 31 minutes have a cordial conversation, just like the defendant described their relationship. That's how you know there was no issues. If there was prior beef, prior issues, conflict, two people who have such a conflict don't sit next to each other at a huge bus station, at a huge transit center. That doesn't make sense. That's not reasonable. It's not logical. You all have common sense. We asked you during voir dire, if you could use that common sense, if you could weigh the facts and the evidence applied to the law. We ask that you use your common sense. Did you do that? And when you do that, it's clear that there was no issue. That the video corroborates that. And then the defendant's conduct. So I want to talk about some of the things the defendant did and what the defendant didn't do. Now, absolutely before, during, and after, there's no report by this defendant in regards to any conflict between him and Mr. Mosley. Nothing at all. Before the shooting, he's a convicted felon who is constantly carrying a firearm. During, he gets up from the bed that we talked about and executes the victim, Mr. Matheson's case. After, there's still no report of any conflict, no report that he was acting in self-defense, that he was protecting himself from serious bodily injury or death, nothing. Instead, after you've got evidence of consciousness of guilt, the defendant didn't stay on the scene, he didn't call 911, he didn't call anyone to tell them that he had to protect himself on August 11th. He fled the scene, he was found hiding in the attic, he hid the gun, and he tells Detective Steele that the relationship between him and Mr. Mathis was cordial. And I say that, I've said it over and over again, because yesterday, Ms. Wood said several times that Detective Steele didn't go to Tip Top. Detective Steele didn't go talk to the friends and family of the defendant, of Mr. Mathis. Why would he? Think to yourself, why would he? He had the source, the defendant, tell him there was no issue. You can't go searching for something where the other party, the source, tells you it doesn't exist. That doesn't make sense. Why would you search for something that you were told did not exist? If there was a conflict between this defendant and this victim, if this defendant was having to defend himself from serious bodily injury or death, you better believe he would have told the detective on August 14th. He didn't, because he knew if he did, the detective was going to do his job, and he was going to follow up on the things that he said. So he said the relationship was cordial. So he didn't. So he couldn't, at that moment, get caught in a lie. Again, no report before, during, and after. Doesn't tell anyone. You heard about the statement that he gave on August 14th, 2014, after he is eventually removed from the attic. And he talks about how he knew Mr. Mathis. He talks about him starting his job in March of 2023. But again, the key thing is he says the relationship is cordial. And you hear on that video, Detective Steidel say, after the defendant says cordial, he says, oh, okay, so it's cordial, it's cool. So you never had an issue with him or anything. And you hear the defendant say, no. There's his opportunity. But he says no. Then we hear the testimony of the defendant yesterday. We all heard it for the first time, sitting in the courtroom together. And we heard on direct that the defendant said that Mr. Mathis was a cool guy, he had no issues with him, they were able to relate, that they had been sitting for about 15 minutes, is what he told Ms. Wood. And that's when Mr. Mathis briefly flashed an object from his book bag, but he told you as he sat there on direct, he didn't see what the object was, he had no idea what it was. He then asked, the defendant had said the victim asked something about getting robbed, the possibility of getting robbed at work, and then followed up with the possibility of getting assaulted at work. He then told us after these questions about getting robbed or assaulted, then this bounty came up, and he told us at the beginning of his testimony on direct about this bounty, that the bounty started at work, and that the bounty was taken out by people at Tip Top, And that's what he told us on direct. He then told us that the conversation kind of ceased between him and Mr. Mathis, but then Mr. Mathis began kind of muttering under his breath and muttering things that made him feel uneasy, that made him feel nervous, and he felt so uneasy that he stood up and shot Mr. Mathis and said he didn't want to shoot Mr. Mathis. Then he told us about being in the attic, and he literally said he fled from the scene and he stayed in the attic for 48 straight hours is what he told you on direct. Then on cross, that changed. Things changed, things were added, things changed, were added. And he said he shot Mr. Mathis, obviously with the gun that we found in the attic. He told us that. But at that point, he had heard the testimony of Kelsey Nash, so he couldn't say anything different because he knew at that point that the shell casings and the projectiles removed from Mr. Mathis came from the gun that was seized from his home in the blue bin. He admitted that it was him and the clothing, and that all the clothing was his. And then I asked him about the attic, and I wasn't trying to be graphic or vulgar, but I asked, in the photographs, it's clear that he had to come down because it didn't look like he had, used the facilities up there because there wasn't any, and it wasn't everywhere. And at that point, he said, "Oh, well, I had free reign in my house. It's my house, and I have free reign." Clearly that he didn't stay in the attic like he told you on direct for 48 straight hours. He went into that attic when the police arrived at his home the early morning of August 14th of 2024. Then asked him about this bounty. At one point, he told me I was threatening, and that I could be somebody who was trying to fulfill the bounty. I was confused by that. But then we started talking more about the bounty, and as we started talking more about the bounty, it became less about the bounty was something that someone at work had put on his head for $50,000. He then decided to say that the bounty was something that came about as he was leaving prison in November of 2022. Changing the story again as to when the bounty and who the bounty had been taken out by. And then I further asked him because he said the only reason he got the firearm 8 months earlier was again about the bounty that he found out about at work. Well, 8 months earlier is in November of 2022. We're in 2023 because he started working at TikTok at March of 2024. And I bring that to your attention. I know it sounds crazy and I know it sounds confusing, but it was. And it sounds crazy and it's confusing because they're all lies. He can't keep track of the lies that he's telling. And as he sat there before you, as I was asking him questions, which he found threatening, it's because he couldn't come up with the answers that made sense quick enough. And that's because when you're not telling the truth, it's hard to remember all the lies you told earlier. You can't keep the lies straight because you can't remember the lies that you told. And he kept digging the hole deeper. That's the point. That's why I kept asking about the bounty. I know I beat a dead horse over and over again a couple times as it relates to the bounty and him being in the attic, but I did that so you could see the lies that he was willing to sit before each and every one of you can tell. And we talked about this as it relates to what's said on the direct about the flashing of the item 15 minutes into sitting on the bench, and then how that evolved on cross with a gun coming out of a bag and being hidden by a phone. And we couldn't see that because the column was blocking or in the way of the things that were described, which is what Ms. Wood told you during closing. Would say that's true. Would say that all of this happened behind the balcony. The balcony, or excuse me, the pole, the column. Well, the pole and the column only obscures the views. It doesn't eat up evidence. Evidence doesn't get absorbed into the columns. If what he said was true, there would be a gun and a phone on the floor near his column. But there wasn't. And it's not because the column somehow absorbed it. It's because it didn't exist. is because he lied. Because if the column was absorbing evidence, it would have absorbed the shoe that was right next to it from the victim where it fell. As he was shot and rolled in agony and pain, wondering why on the floor. You cannot see what's not real. Ms. Wood kept saying that you can't see things, look for things that aren't presented to you. Well, things can't be presented to you that don't exist. That's what they wanted the state to present. Things that don't exist, things that didn't happen. And unless something's changed, there's no magic that allows anyone to present things that didn't happen and that don't exist. And all of that was their defense tactic. Their tactic is to distract you, to send you on detours, and derail you from actually seeing what's straight in front of you. And you heard Mr. Rao, and you heard Ms. Wood talk about cereal and grocery store honeycombs and on the box or the front of the cover. And then Ms. Wood talked about inside the box is could be, I guess, bugs, I think she said. But what the defense wants you to do is dump the honeycombs onto the ground, see honeycombs, look at the honeycombs, then look at the state and say they're Fruit Loops. That's what they want you to do. They want you to ignore what is right in front of you and think it's something different. That's what the defendant tried to do to you yesterday. He tried to take you on the detours, derail you from seeing the facts and the evidence, and the fact that he shot and killed Mr. Mathis in cold blood. Ms. Wood, towards the end of her closing, talked to you as part of the defense closing about the knife, which we've talked about. It's not relevant because the defendant didn't know it existed. And how could anyone be hiding anything from anyone when he included it in his property and evidence report? How do you hide something that you record? It wasn't presented to you because it wasn't relevant. The defendant didn't know about it. We talked a little bit about how Detective Steedle should be ashamed, but what Detective Steidel actually was able to do, in the state's opinion, was find a needle in a haystack over and over again. He was able to go through hours and days of video surveillance and find the defendant in the plaid shirt, find the defendant using the breeze car. He told you that he looked for all the angles of the shooting on August 11th, and there was only one. He told you that. Defense counsel wants you to believe that there were other angles that he didn't get. But he told you as he sat there, he attempted to get every angle, and he did it. That was the only angle that actually captured the bus loop where the shooting occurred. He didn't do a very good investigation because he asked for assistance or help because he had been up for 24 straight hours. So members of his team went to Tip Top, and it was a shameful act for not going to Tip Top himself days after. But again, he had spoken to the defendant who said there was no conflict. So why would he? And then the defense counsel said that what the defendant told you yesterday, he's been saying since day one. Day one, he's been saying self-defense. Well, day one, he didn't say anything. He fled. Day two, according to him, he was in the attic. Day three, still in the attic, 48 hours. Then day four is when he's found in the attic by the Atlanta Police Department. And he's interviewed by Marta. And what he tells Marta, not that it was self-defense, not that he felt threatened, not that he felt as if he was about to receive serious bodily injury or death, but that the relationship between him and Mr. Mathis was cordial. So day one, he's not saying self-defense. Day 319, which was yesterday, that's the first time any of us heard that this defendant was acting in self-defense. Day 319. We talked about some of the things the defense counsel has said about what you don't see. And the reason is you don't see them is because they don't exist. There is no gun. The only way, the only words you can use to describe what this defendant did on August 11th of 2024 is he did it. He made conscious, deliberate, and intentional decisions that day. And those decisions led to the death, the untimely death of Mr. Mathis, ending his life, taking him away from his family, taking him away from his job. For what? Mr. Mathis didn't know. The last thing he wanted to know, as this defendant made these conscious, deliberate, and intentional decisions that took his life in seconds, was why. Ladies and gentlemen, I thank you for your time. I know at times it seemed as if we were wasting time because technology wasn't working. We tried to warn you at the beginning about that. But this defendant wants you to not see what is directly in front of you. This defendant wants you to ignore everything that you saw so he can escape accountability. You, ladies and gentlemen, are the last body of people that are standing between this defendant and holding him accountable. And what will hold him accountable is that after you go back into the deliberation room and you deliberate, you return with the only verdict that speaks the truth, the only verdict that holds this defendant accountable, the only verdict that gets justice for the murder of Mr. Max. And that verdict won't be something the defendant doesn't already know to be true. And that's this defendant is guilty of all counts. He's guilty of murder. He's guilty of all 3 counts of felony murder. He's guilty of aggravated assault, the 2 counts of possession of a firearm by a convicted felon under the 131 statute, and he's guilty of the last possession of a firearm count under 133. I thank you for your time. Thank you for your attention. Thank you.
Thank you, Mr. Abate. Ladies and gentlemen, if you want to stand for a second, you can. We're not going to take a break before I give you the charge. The charge is about 15 minutes. But it is a shift from focusing on what the evidence is or isn't in the case to the law. A couple things about the charge. One, this is it, and you will have this document with you. So you're welcome to take notes. I do my best to make the language, the term I use is accessible, so I understand it and you understand it, and everyone else. There are some legal concepts that I'm required by higher courts to describe in certain ways, or required by statute to describe in certain ways. So you're actually going to hear me say the phrase abandoned and malignant heart. I would not normally say that to anyone, but that's part of the definition of the crime of murder. And you'll be deciding what an abandoned and malignant heart means. It has nothing to do with cancer, but it has to do with intent and state of mind. So I'm apologizing in advance if there's some phrasing in there that seems stilted. I'm doing my best to communicate to you what the law is because you have to apply it. So it's important that you understand it. But you'll have this document to review. And as I read along, it'll actually be up on the screen. If you're someone who likes to see what someone is saying, it'll be up on the screen as well. So let me make that happen. Deputy Gordon, your morning project. You good? Be nice for IT to end on a high note for us and actually have a static device like a screen work. All right. Sorry I wasn't on earlier for the PowerPoint from the state, but here we go. All right. Let me shrink that. A grand jury has indicted the defendant, Mr. Mosley, for murder, felony murder, aggravated assault, possession of a firearm during the commission of a felony, and several counts of possession of a firearm by a convicted felon. Reminder, it's not on the screen, you'll have that indictment during your deliberations. That goes back with you along with a verdict form and this jury charge or jury instructions and almost all of the evidence that was admitted. There may be a few things that don't go back, but I'll talk about that in a little bit. The defendant has entered a plea of not guilty to these charges. Neither the indictment nor the plea of not guilty is evidence. The defendant is presumed innocent. This presumption remains with him unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. The state must prove beyond a reasonable doubt every material allegation of the indictment and every element of each crime charged. And I'll be giving you those elements later on in this charge. There's no burden of proof upon the defendant, and the burden never shifts to him. If the defendant presents a defense, the burden is on the state to disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says. It's a doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth, which is what you will be doing. It does not mean a vague or arbitrary doubt, but is rather a doubt for which a reason can be given. And that reason arises from your consideration of the evidence, lack of evidence, or conflicts in the evidence. If after considering all that evidence, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant grave suspicion of the crimes charged or merely raises speculation as to his guilt is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law. That's what I'm doing right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence presented. You must then apply the law I give you to the facts that you find. You must decide this case based only on the evidence presented during trial. That evidence consists of testimony, exhibits, and a stipulation. And you'll have that written stipulation. I think it's Exhibit 161, but you'll have that with you during your deliberations. Evidence does not include the indictment or plea of not guilty, anything that I've said, anything the lawyers have said, to include their opening and closing remarks. And evidence also does not include any questions posed. And the significance of that is that you all, I had already given them to the court reporter, I think it was 81 note cards worth of questions. Not every question was asked. You should not draw any inference or conclusion from the fact that your question was not asked, because questions aren't evidence. It just means that was a question that wasn't legally permissible. Evidence is what witnesses say in response to questions. Now, that evidence you've received may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, an eyewitness. I saw the red car run the red light. I saw it. I'm an eyewitness. Circumstantial evidence is proof of one or more facts that tend to prove some other fact by inference. I didn't see the accident, but I heard tires screeching and it sounded like metal striking metal. That's circumstantial evidence that there was a collision between cars or a car and something solid. There's no legal difference in the weight you may give to direct or circumstantial evidence. In considering the evidence, you are free to use your reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. The parties have entered into a stipulation about the defendant's status as a convicted felon. When parties stipulate to facts, you must take those facts as a given without further proof. Now, this is something we talked about before we started the trial. One of your jobs is to determine the credibility or believability of the witnesses. In deciding this, you may consider all the evidence you've received, the witnesses' manner of testifying, their basis for knowing the things about which they testify, the probability or improbability of their testimony, and their interest or lack of interest in the outcome of the case. The credibility of a witness may be attacked by disproving facts to which the witness testified. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. And your assessment of a witness's credibility may also be affected by comparing that witness's testimony to you to statements that he or she made before trial. And you have to decide if there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You heard from several expert witnesses. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. The testimony of an expert, like that of all the witnesses, should be given only the weight and credit you believe it should receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided you find that witness's testimony to be sufficient. The state must prove the identity of the person who committed the crimes charged beyond a reasonable doubt. Your determination of identity is dependent upon the strength of the evidence offered for this purpose. A statement that the defendant allegedly made while in custody has been admitted. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary and whether the defendant was properly advised of his constitutional rights. Sometimes evidence is admitted for a limited purpose. In this case, the stipulation that the defendant is a convicted felon is such evidence. You may consider that stipulation only insofar as it may prove an element of counts 7, 8, and/or 9, and for no other reason. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, but is simply the intent to do the thing that is illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find that intent, or the absence of it, from consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendant is being prosecuted. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the crimes alleged here, committed here in Fulton County, must be proved by the state beyond a reasonable doubt. All right, now we get into the specific charges for the crimes that are alleged in the indictment. Count 1 is murder. For murder, the state must prove 3 things: that the defendant, 1, caused the death of another person, 2, that he did so unlawfully, and 3, that he did so with malice aforethought. It's one of those phrases. The killing must have been done with malice to be murder. But importantly, malice, as it is used here in the context of what is murder, that does not necessarily mean ill will or hatred. Instead, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another. You may also find malice when there does not appear to be significant provocation and the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, and again, that means unlawful intent, it's done with unlawful intent, it is murder regardless of how briefly that malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice, that criminal intent, was in the defendant's mind at the time of the act that killed, and it moved him to do it, that is enough for the killing to be murder. Proof of motive is not an element of the crime of murder. Evidence of motive, if any, has been admitted for you to determine whether it establishes the defendant's state of mind at the time of the killing. Counts 2, 3, and 4 in the indictment all charge felony murder. For felony murder, the state must prove two things. They must prove that the defendant, 1, caused the death of another person, 2, by committing some other felony. The state does not have to show that the defendant acted with malice, that is, the unlawful intent to kill, in order to prove felony murder. Aggravated assault and possession of a firearm by a convicted felon, as they're charged in this indictment, are all felonies. You may find the defendant guilty of felony murder if you believe that he caused the death of another by committing aggravated assault or possession of a firearm by a convicted felon, as that's charged in the indictment, regardless of whether he intended the death to occur. There must, however, be some causal connection between that other felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was committed. The felony, aggravated assault, or one of these gun charges, must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Aggravated assault. Count 5. A person commits an assault when he attempts to commit a violent injury to another. A person commits an aggravated assault when he assaults another with a deadly weapon, and a firearm is a deadly weapon. Possession of a firearm during commission of a felony, which is count 6. A person commits the offense of possession of a firearm during the commission of a felony when he possesses a firearm during the commission of a felony. Murder, felony murder, and aggravated assault are all felonies, and the term firearm includes any handgun. Possession of firearm by convicted felon, as it is charged in counts 7 and 9. 9 is the allegation from a later date, the August 14th date. For possession of a firearm by a convicted felon, as it is charged in counts 7 and 9, the state must prove that the defendant possessed a firearm after having been convicted of a felony. And again, firearm includes any handgun. And finally, possession of a firearm by a convicted felon during the commission of a felony, which kind of sounds like a mashup of counts 6, 7, and 9. It's what's charged in count 8. For count 8, for that allegation, as it's charged, the state must prove 4 things. That the defendant, 1, had on his person or within arm's reach, 2, a firearm, 3, during the commission of a felony against another person, and 4, after having been convicted of what we call a qualifying felony. And that's referenced in the stipulation as well. Again, the term firearm includes any handgun. Murder, felony murder, and aggravated assault are all felonies against another person. That's the phrase in element number 3. Affirmative defenses. The defendant has raised the defense that there were circumstances that justified his conduct. Once such a defense is raised, the state must disprove it beyond a reasonable doubt. Sometimes a defendant's use of force is legally justified and so is not a crime. An example of that is self-defense. A defendant is justified in using force against another that is intended or likely to cause death or serious bodily injury when, number 1, he reasonably believes that the use of such force is necessary. Number two, to prevent death or serious bodily injury to himself. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide the defendant's actions in this case were justified, it would be your duty to find him not guilty. Now, for a defendant's use of force to be justified, he must have believed that his use of force was necessary. And that belief must be reasonable. That is, a reasonable person would also believe that the use of force is necessary. And finally, the defendant's reasonable belief must have been what prompted him to use that force. A person who is not the aggressor is not required to retreat before being justified in using force he reasonably believes to be necessary. A defendant's use of deadly force may be justified even when there has not been physical contact between anyone, if the menacing actions of the alleged victim is sufficient to create a reasonable belief that the defendant's life is in imminent danger, then the defendant's use of deadly force may be justified. However, words alone never justify the use of deadly force, no matter how abusive or provoking. If you find that the defendant used force in self-defense, but that the force used exceeded what the defendant could reasonably believe was necessary to defend himself, the killing is not justified. Ladies and gentlemen, you should consider each count of the indictment individually. The defendant may be found guilty of some, all, or none of the charges. If, after considering the evidence together with this charge, which is almost done, you should unanimously, all of you, find beyond a reasonable doubt that the defendant did commit here in Fulton County any of the crimes alleged in the indictment, you would be authorized to find him guilty. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty. And you would, on this verdict form, check that option, guilty, on the verdict form for that offense. If you do not believe the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. And you would check that option on the verdict form for that offense. Again, whatever your verdict is for a particular count, it must be unanimous. Your verdict must also be in writing on this form, signed by your foreperson and dated. And here's an example. That's what it's going to look like for count one. We find the defendant, and if you decide that the state has met its burden of proving his guilt beyond a reasonable doubt, you'd be authorized to check guilty. If you have any reasonable doubt or you're convinced that he is not guilty, then you would check not guilty. By no ruling or comment that I have made during this trial have I intended to express any opinion about the credibility of any of the witnesses, about the strength or weakness of the evidence, or the possible guilt of Mr. Mosley, the defendant. Your verdict must be based solely upon your consideration of the evidence, according with the laws I have given you in this charge. It's your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you perceive that one of your jurors is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. You are, as I have told you several times, the fact finders in this case. You are not to concern yourselves with punishment. That is a role for the judge. One of your first jobs in the jury room will be to select a foreperson who will preside over your deliberations and who will sign that verdict form to which all of you freely and voluntarily agree. Please start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. During your deliberations, you may not communicate with anyone outside your group about this case, nor may, unsurprisingly, you conduct any outside research. You have all the evidence in the case. It would be improper to supplement it with any outside information. And to assist you in complying with this instruction, Deputy Gordon will be collecting all your electronic devices, including smartwatches, while you deliberate. I promise you get them back. But while you are in a jury room deliberating, your devices are beeping and booping in my office. And I give them to you when you are done. From here on out, if you need to communicate with me for any reason, it needs to be in writing. You're good at it, write it on a note card or a piece of paper from your notepad. I will receive your question or note, talk with the lawyers and Mr. Mosley, and I will respond however the law allows me to respond. And that last note's an important one. You may ask a great question and you may be wrestling with something. And my answer may be, you got to figure it out. Sometimes I'm not allowed to tell you more than that. And do not, and you're free to do it, but if you send a question back, hey, could you replay the testimony of person X? I'll write back and I will say, nope, because there's no replaying of testimony. Now we can play videos again if you want to watch a video, and you'll have most of the evidence with you. That kind of thing can happen, but there's no transcript for you to review. I may say, you just have to read the jury charge again. If you say, could you help us with that reasonable doubt idea? I will say, I did the best I could by giving you the law that I'm allowed to give you on what reasonable doubt means. But we'll do our best to respond in a way that is meaningfully responsive to your questions. Okay? Before you head back and cough up your electronic devices, I need Mr. Shane and the birthday juror to stay put. The other 12 of you, please go back to the jury room. Do not begin your deliberations. You can pick your foreperson and all that kind of stuff. Don't begin your deliberations until Deputy Gordon brings you, he's going to bring you a bin that has all the evidence, the indictment, the jury charge, meaning the instructions, and the verdict form. Once you get that, you're off and running. Before then, you can just figure out who your foreperson is going to be. Okay? Thank you.
All right, for the jurors.
Mr. Rao, would you grab the verdict form? We'll make sure it meets the state's and the defense's expectations. All right, everyone can be seated. You two are alternate jurors. We don't tell you that in advance because then you just leak through the trial. You are going to remain here. You're going to be, I think the other room is not so much. We're going to find you a space to be. You get to keep your electronic devices. Don't do any research related to the case. You can do work, you can sleep, you can talk. Don't talk about the case. But I'm going to have you stay here today as long as this group is deliberating. We might have to excuse someone. And if we do, one of you actually gets pressed into service and they have to restart. You don't need to worry, well, I'm coming in halfway through the conversation. If we had had to excuse a juror mid-trial, it would have been invisible to you. Unbeknownst to you, one of you would have moved into the non-alternate pool. But if it happens now, the instruction to the other 11 will be start over. And they'll start over, and then you will join in the deliberations. When they break, we'll let you know they're breaking so you can break. I'm figuring out what we're doing for lunch. If we go that far, you'll be part of that. And certainly, should this group reach a verdict, I'll receive that verdict, and then we'll bring you in as well once they've done what they need to do. But I do need you to remain in your information cocoon. The two of you shouldn't talk about the case or do any outside research, but you get to keep your devices to do with them whatever would be appropriate to do with them. So if you'll go with Deputy Gordon, I don't know where he's taking you. He'll tell me. It'll be somewhere on the floor. Usually we put people, there's an alternate jury room there, but there's a lot going on in that courtroom. So it may be one of my colleagues' jury rooms down the hall. You will not be forgotten. Okay? Thank you.
May I approach?
Yes. All right, we'll get that on the record. Mr. Rao, did you get a chance to look at the verdict form?
I did, Your Honor. No, it.
And Ms. Wood, you just told me no issues from the defense. So that'll go back with the jury charge. I don't know that we need to redact anything from the indictment now that states 1 and 2 are in, and I believe states 1 and 2 will go back with the jury the way they were deployed in the case and the fact that Mr. Mosley testified. But that's just my thought. I'm open to suggestions if you think there are redactions that are justified in the indictment. Okay. All right. Any thoughts about redacting the indictment now that things have unfolded the way they have, Mr. Rao?
I think it's a moot point at this point, given the fact that the reason for the redactions are no longer relevant, given that the convictions were entered.
Right. The stipulation is now a little, it's necessary, but its role is a little attenuated as well, but it's been admitted. And so I think it should go back as well. And it fixes that little piece about qualifying offense. Okay, so Ms. Wood, you can take a second to think through redactions. And then I need you all, and I should have done it, asked you to be thinking about it while I was charging the jury. Well, first, any exceptions to the charge as given, Mr. Rao? Ms. Wood?
No.
Okay, I need you, the two sides, to confer about what does go back with the jury and what doesn't. And while you're doing that, because the firearm's secure, it can go back with the jury, can't it?
Yeah.
Okay,
I just want to take ammunition.
okay, we'll keep the ammunition here. They can ask to see the ammunition if they want to see that.
I think we are in agreement, everything can go back.
Okay, including the ME's, the only thing I think of would be the ME's report. I don't think it's a swing issue in this case.
Yes, sir.
Okay, that makes it easy. Then Deputy Gordon, here is the indictment and the verdict form and the jury charge, and all the evidence goes back, except you'll want to fish the evidence, the ammunition out. Although, I mean, with that thing in the barrel, the guy, you're in charge.
It was
If, oh, so one last thing. They'll start their deliberations, we'll say 11 o'clock. And Mr. Mosley, you will be brought out here anytime we're working substantively on the case. So if there's any question or note from the jury, you'll be out here to see it and understand what your lawyers have to say about that. I'm not going to bring you out here if it's simply me coming out saying, hey, the jurors are having lunch now. Obviously, if there's a verdict, you'll be out here for that as well. Otherwise, you'll be waiting right back there. Okay? All right. Anything else, Ms. Wood, before we adjourn?
Here.
All right. Mr. Abadi?
No, you're not.
Okay. Thank you. Can you carry all that? Okay.
If not.
AC jury room.
Oh, she's using that, but not that.
It's a civil jury one.
Okay, cool. Ms. Wood, can you put a phone number that will suffice to notify your side and then get one of the prosecutors to write a phone number for that? Thanks. I will mute things here. Ms. Rivers, are you ready? We are back on the record in State versus Mosley. Mr. Mosley is in court with his lawyers. The prosecutors are here, and the jurors got Deputy Gordon 2 notes. The first says, 1, CCTV of gentlemen sitting on bench. And the second one says, 2, body cam of Officer Marthone. I am interpreting these as a request to watch the video. And my suggestion is we ask Deputy Gordon to ask the jurors if they want to watch the entirety of the MARTA video where Mr. Mathis and Mr. Mosley are sitting on the bench, or just a little snippet. And if they say the entirety, then we will get them a means of playing it and reviewing it in the jury room, rather than we all sit out here for the 40 minutes of the MARTA video and whatever the duration of Officer Marthone's body cam is. Mr. Abadi, any issue with that? Ms. Wood?
No.
Okay. You comfortable asking them, did they want to watch the whole MARTA video or just a little piece of it? And they can do either one. It just, that'll impact where they are. Thanks.
The entire.
The whole thing. Okay. Then, are there other videos? Because it's easiest if you just put everything on a thumb drive, then so we're clear on the record. There is in the jury room, a monitor about this size that has a little computer attached to it that has on it only, it has no internet access, and it has on it only video and audio playback software. And so in previous trials, what we've done is put all of the video evidence, defense and state, whatever it is, onto a thumb drive, push that onto the desktop of that computer, and then they can play it and discuss it any way they want. And I'm just not remembering what, I know there is the statement that Mr. Mosley gave to the detective. There's Marthone's video, and then I guess there's buses and trains. I don't think we need all that. I think it would just be, why don't we just give them these 2 things, because that's what they asked for. If they ask for more, we can work through that.
Okay.
All right, Ms. Wood, that work for you?
That works for me, Judge.
All right. And you'll get your thumb drive back.
Okay.
What would Mr. Sprinkle have testified to? And Detective Hunter?
He was involved with getting Miss Bell from Chamblee. He was the connect.
Got it. taking a long time to copy, or are you playing
Hard copy.
solitaire?
It's got another 4 minutes.
4 minutes. That's a big file.
2 million, whatever.
One of those units.
Hey, let's get it out. Yeah, you got one.
So I'm gonna go get it set up in there. If you can just bring me the thumb drive, it'll be great. Ms. Wood, anything else we need to talk about at this point? Their food is arriving soon, but I think they're gonna just stay back there and eat, and we'll figure out how there can be a pause so that the alternates can get food as well, but not be part of the deliberations. All right, Mr. Mosley, we'll bring you back out when something happens. Thanks, everyone. So they handed Deputy Gordon a question while we were in there putting the videos on. Are you able to get Mr. Mosley, or do we need Deputy Gordon back? Okay, thank you.
It's like hot in here earlier this week, but recently I was having issues with so we still like. Yeah. I was saying, I was like, oh, yeah, everything's changed, so.
Ah, right here. Can you get the thumb drive out of there? Plug it out. Thanks.
You know where that is?
Let's take it.
Goes with it, you give it to Mr. Body. All right, Ms. Rivers, are you ready? We're going to get back on the record in State versus Mosley. Mr. Mosley is in court with his lawyers. We have our prosecutors here. And what I will call question 3, it's card number 3. One of the jurors wrote, when defining unanimous, does this mean all 12 jurors must have beyond a reasonable doubt? Question mark. If one juror has reasonable doubt, does this mean the count they have reasonable doubt for would be not guilty due to the one juror? Question mark. When defining unanimous, does this mean all 12 jurors must have beyond a reasonable doubt? If one juror has reasonable doubt, does this mean the count they have reasonable doubt for would be not guilty due to the one juror? My thought is an answer along the lines of a verdict of guilty or not guilty must be unanimous, meaning all 12 of you agree. A non-unanimous situation is not a verdict, and you should continue to discuss it. Words to that effect. Does that work for the state?
Yes, Your Honor.
Ms. Wood?
Yes, Judge.
I wrote on the back, a verdict of guilty or not guilty must be unanimous, meaning all 12 agree. A divided decision is not a verdict, and you should continue to discuss to see if agreement can be reached. Does that work for the state and the defense? Is it also perfect?
I wouldn't go that far.
All right, I'm gonna take it back to them. You all can be at ease. And as always, Mr. Mosley, we'll bring you out here if they have a question or anything else, okay? Thank you. Hello, everyone. So we have a verdict. If we can get Mr. Mosley out here, please.
Yeah, exactly. Okay, guys. I think it's. No, I think that's what she wants. Which are.
Oop, we need Ms. Rivers. I thought she was out here.
Absolutely.
Deputy Gordon's gonna get it. Did she pass you? Okay. They'll be going in this circle. Where is she? No. Ms. Rivers, are you ready? All right, we're back on the record in State versus Mosley. It's around 3 o'clock and Deputy Gordon has informed me that the jury has reached a verdict. Mr. Mosley is in court with his lawyers. We have our prosecutors and I'm ready for the jurors to come in. Mr. Abate, anything from the state before the jurors return?
There.
Ms. Wood?
Mayor.
Let's bring the jury in, please.
Rounds of the jury. Jurors are present and accounted for.
Thank you, Deputy Gordon. Everyone should be seated, please. One of you is the foreperson. You are the foreperson. Have you reached a verdict with you and your 11 colleagues?
Yes, we did.
Was it a unanimous verdict?
It was unanimous.
And have you signed the verdict form?
Yes, sir.
All right, if you could give it to Deputy Gordon, please. All right, sir. I'm going to ask you to do what we call publishing the verdict. So if you would stand and read the verdict into the record, you don't have to read the stuff at the top. You can just start with count one because we know what case we're here for.
So we, the jury, on count one of murder, we find the defendant guilty. On count two, felony murder and aggravated assault, we find the defendant guilty. On count three, felony murder, possession of firearms, count seven, we find the defendant guilty. Count four, felony murder, possession of firearms, count eight, we find the defendant guilty. On count five, aggravated assault, we find the defendant guilty. On count six, the possession of firearm during commission of felony, we find the defendant guilty. On count seven, possession of firearm by a convicted felon, we find the defendant guilty. On count eight, possession of firearm by a convicted felon, we find the defendant guilty. On count nine, possession of firearm by a convicted felon, we find the defendant guilty.
Thank you. Deputy Gordon, if you would get the verdict form to the prosecution and then to Ms. Wood. Mr. Abadi, any objection to the form of the verdict? Thank you. Ms. Wood, any objection to the form of the verdict?
No objection.
Mr. Abadi, any reason I cannot excuse or release the jury at this point?
None from the state, Your Honor.
Ms. Wood, anything else?
No, I'd like to poll the jury.
Okay. Ladies and gentlemen, polling the jury simply means confirming that this verdict was the verdict of each of the 12 of you. So what I'm going to do is call you one by one and ask each of you the same 3 questions. If when I call your name, you would answer those questions, I would appreciate it. And we start with Ms. Wills. Ms. Wills, was the verdict that we heard out here your verdict in the jury room? Did you freely and voluntarily enter into it? Is it still your verdict? Thank you. Mr. Bayona, was the verdict read here your verdict in the jury room? And did you freely and voluntarily join that verdict? Does it remain your verdict? Thank you. Ms. Mammon, was the verdict read here your verdict in the jury room? Did you freely and voluntarily enter into that verdict? Is it still your verdict? Thank you. Mr. Britton, was the verdict read here in court your verdict in the jury room?
Yes.
Did you freely and voluntarily enter into that?
Yes.
Is it still your verdict?
Yes.
Thank you, sir. Ms. Bolton, was the verdict that you heard read in court your verdict in the jury room?
Yes, Your Honor.
Is that something you freely and voluntarily entered into?
Yes, Your Honor.
Does it remain your verdict?
Yes, Your Honor.
Thank you. Ms. Suggs, was the verdict read here in court your verdict in the jury room?
Yes, Your Honor.
Did you freely and voluntarily enter into it?
Yes, Your Honor.
Is it still your verdict?
Yes.
Thank you. Ms. Thompson, was the verdict read in court your verdict back in the jury room?
Yes, sir.
And is that something you freely and voluntarily entered into?
Yes, sir.
And is it still your verdict?
Yes, sir.
Thank you. Mr. Moore, was the verdict read here in court your verdict in the jury room?
Yes, Your Honor.
Did you freely and voluntarily enter into it?
Yes, Your Honor.
Does it remain your verdict?
Yes.
Thank you. Ms. Hilton, was the verdict you heard in court your verdict in the jury room?
Yes, Your Honor.
And did you freely and voluntarily enter into that? Is it still your verdict? Thank you. Juror Harrison, our 4-person, was the verdict that you read in court your verdict back in the jury room?
Yes, sir.
And did you freely and voluntarily enter into it?
Yes, Your Honor.
Does it remain your verdict?
Yes, Your Honor.
Thank you. Is it Malley or Maley? Mr. Maley, was the verdict you heard in court your verdict in the jury room?
Yes, Your Honor.
Is that something you freely and voluntarily entered into?
Yes.
Is it still your verdict?
Yes.
And last but not least, Mr. Hanks, was the verdict you heard in court your verdict in the jury room?
Yes, sir.
And did you freely and voluntarily enter into that?
Yes, sir.
Is that verdict still your verdict?
Yes, sir.
Thank you. Ladies and gentlemen, on behalf of the litigants in this case and members of our community, our shared community, I want to thank you for this week. You've given us a week of your life to resolve an important issue for Mr. Mathis, for Marta, for Mr. Mosley, and a number of other people who were involved. And it wouldn't have happened without your commitment to the process. So thank you for that. I'm going to ask you to retire to the jury room. In a moment, you will be reunited with your 2 alternates, your electronic devices, a letter saying you've been here all week. And I'm going to come back and thank you again and talk to you about a couple things, and then you'll be able to be on your way. Thank you so much.
All right, jurors.
Mr. Bate, what's the state's perspective as to when we ought to do the sentencing for Mr. Mosley?
I'll leave it to this discretion of the court today is fine with the state.
Okay, I just wasn't sure if there were family members. I'm not clear on whether there'd been family members here or if they wanted to be present for a sentencing.
Mr. Max's father and sister are both present.
Okay. Ms. Wood, any objection to handling sentencing today?
No objection.
Okay, then we'll do that. I'm gonna talk with the jurors real briefly. I'll let them know that they're welcome to stay, in particular if they want to give feedback to the lawyers or watch the sentencing or both. And then I'll be right back and we'll take up sentencing. Thank you.
Hey, Jens.
Yeah. Him? We'll see. Can we bring Mr. Mosley out? Someone's getting him? Okay. Ms. Rivers, are you ready? All right, let's get back on the record in State versus Mosley. We have Mr. Mosley out here and it's time to talk about sentencing. Mr. Abate, I'm ready to hear from the state as to your recommendation, anything you want to add, and if any of Mr. Mathis's family members want to be heard. Of course, I'm happy to hear from them.
Yes, Judge.
Okay?
Good afternoon, Judge. As it relates to Mr. Mosley and sentencing, the state did file on April 10th this year a recidivist notice where Mr. Mosley is both an A and B offender. The fact that he is an offender under 1710(7)(b) requires that he receive a life without the possibility parole sentence as it relates to count 1 murder. Counts 2, 3, and 4 would all vacate by operation of law. Count 5, aggravated assault with a deadly weapon, would merge with count 1. Count 6, possession of a firearm or the commission of a felony, would merge with count 8. Count 7, possession of a firearm by a convicted felon, would merge also with count 8. Count 8, which is the possession of a firearm by a convicted felon under OCGA 1611-133. The recommendation from the state is 15 years to serve consecutive to the life without the possibility of parole sentence. And then the last count, count 9, possession of a firearm by a convicted felon, be 10 years to serve concurrent with count 8, Your Honor.
All right.
Both Mr. Mathis's father as well as his sister, we spoke with them. They just wanted the court to know that they'd be present and that they did not want to make any further statements.
Okay. I appreciate that you are here. I'm very sorry for your loss. And I'm glad that you were able to see that justice was done and that this is not a life forgotten, but one for which the state pursued what it needed to pursue. And hopefully this brings some small measure of closure. It certainly doesn't bring anyone back, but it marks at least a step in the direction of fully appreciating the loss that occurred. So I appreciate you all being here. Ms. Wood, first, do you agree with how the sentence needs to be structured?
Yes, Your Honor.
Okay, and what is your recommendation?
I understand the law, Judge, so I understand there's not much for me to argue here. I would just let the court know that I have filed the appropriate paperwork to begin the next step in Mr. Mosley's process. And I would like the court to know that he has had family members here as well this week.
Okay, and the record should reflect that. I know we took one break and Mr. Mosley was able to confer with his sister about some of the decisions he needed to make in this case, and he has had family here throughout. Mr. Mosley, this is your sentencing, and so you have a right to speak if there's anything you want to say. I know at one point when you were up on the witness stand, you asked if there was something you could add. This may not be the time you want to do that, but I want to give you an opportunity to share with me anything that you want to share.
I'd like to state that I am innocent. I still believe to the best of my knowledge that I did everything to save my life. I'm sorry for the loss of the family, but I was placed in a situation where I had to choose my life or his life. And I did that murder. I'm innocent.
Okay. Thank you, Mr. Mosley. Mr. Mosley, I know that the jury very, very carefully considered the evidence in the case and wrestled with this defense of self-defense. They have delivered the verdict that reflected their careful and thoughtful analysis of the evidence, which included no weapon being recovered on the ground or anywhere near Mr. Mathis, other than a black knife of unknown dimensions inside a zipped backpack. You are entitled to your view on this, but we're moving forward with the verdict that was unanimous and handed down. Your sentence on count 1 is required to be life without parole, given your criminal history. Counts 2, 3, and 4 are vacated by operation of law. Count 5 merges into count 1. Count 6 merges into count 8, similar with count 7. Count 8 must be 15 years to serve. That will run consecutive to count 1. And count 9 will be 10 years to serve. That will be concurrent with count 1. So that's a total sentence of life without parole plus 15 years. Mr. Mosley, you have a right to seek what we call post-judgment relief. That comes in 3 forms. One is a motion for new trial. Ms. Wood has, it sounds like, already filed that. And if it hasn't hit the docket yet, it will soon. That's an opportunity for a lawyer other than Ms. Wood to review the record of this trial, to see if I made errors, if your lawyers were deficient in any way, if the prosecution did something inconsistent with the law. And a lawyer will be appointed to represent you for that motion for new trial proceeding. That will be argued in front of me once the trial transcript is complete. If I deny the motion for new trial, you will have the right to appeal your conviction and sentence to the Supreme Court of Georgia. The same lawyer who handles your motion for new trial will handle that appeal to the Supreme Court. Then if that doesn't go well for you, you also have the right to file what is called a habeas challenge. That's basically a civil lawsuit that further challenges your conviction and your sentence. That is a proceeding for which you're not entitled to have a lawyer, but you don't need to worry about your habeas challenge until you have fully exhausted the motion for new trial proceeding. And if you choose, if your motion for new trial is denied, if you choose to appeal to the Supreme Court, only after the Supreme Court rules, if they don't rule in your favor, do you need to worry about pursuing a habeas challenge. Do you feel like you understand the basic mechanics of how this appeals process that I described will work? Pardon me? Okay, well, I'll be more specific. You have 30 days from today to decide whether you want to pursue a motion for new trial. It sounds like you and Ms. Wood have already talked about that, because she told me she's already started that process, which means she'll file a placeholder that basically says motion for new trial. A new lawyer will be appointed to represent you and will work with you to prepare that motion. It can't be completed until the trial transcript is done. But the placeholder that stops that 30-day clock, it sounds like Ms. Wood will be filing. You don't need to do anything beyond that if you agree with Ms. Wood that she should file that motion for new trial. So I'm going to ask you to speak with her, if you have not already, about whether she should file the motion for new trial. And then you don't need to do anything more for the time being. A lawyer will confer with you once one is appointed about how to proceed with the motion for new trial. That lawyer will be your counselor going forward for the rest of the direct criminal appeal. Mr. Abate, anything else we need to cover before we close this out?
Nothing further to say, Your Honor.
Thank you to you and Mr. Rao for being prepared and moving this case along at a healthy clip. Ms. Wood, anything else from the defense?
Very briefly, Judge, is it possible for us to handle that probation revocation? I do.
Yes. Thank you. Ms. Simpson had sent, thank you for reminding me. Let me find that. If you are waiving any due process notice rights, although someone already, Judge Newkirk signed a warrant in connection with this, so it's actually live and active. Mr. Where is the, oh, it would be from Nelson. Mr. Mosley, your armed robbery case includes a probationary period. That's why you were working with the probation officer. And there are about 2 years and 4 months remaining on that. Judge Newkirk signed a warrant for your arrest on that probation case in connection with you getting arrested in this case, the murder case. And it's my proposal to revoke the balance of that probation and simply run it concurrently with the sentence in this case, so that as Mr. Mosley is navigating where to go next, he doesn't need to worry about that 12 SC case. It'll be closed out as he is serving his sentence in this case and pursuing his appeals in this case. Any objection, Ms. Wood, to handling it that way? Okay, I don't think Ms. Simpson is on the Zoom, but Ms. Nelson and I will make sure that she's notified of that. She'll get me a revocation order and I'll simply revoke the balance to run concurrently with the sentence in the 24 SC case.
District and I am communicating with Officer Simpson. She's following along online.
Well, fantastic. Thank you for having built that link. Anything else from the defense?
Thank you.
All right, well, thank you for your steadfast representation of Mr. Mosley. He was in good legal hands, regardless of whatever the attorney who takes on the motion for new trial has to say. We are done. Lawyers, if you want to stick around, there are some jurors who have agreed to stick around to talk with you about the case. And I'll ask everyone else to head on out of the courtroom.
Good. Yeah. Sorry.